people who came to see the proceedings. We have sat until late. We shall render our ruling on Thursday at 2:30. Thursday is which date? A day after tomorrow, 31st at 2:30.
My lords, perhaps I need your guidance because we had indicated in the morning that we have an application for contempt of court.
Mr. Ndegwa, listen to the instructions and directions of court. We will give a ruling on this matter on Thursday, the 31st at 2:30. After that, we'll provide a way forward for any other matter. Thank you.
I am okay.
Please sit down. Yes, shall we see you on Thursday?
Saiu daí da vinagre.
Because the initial state did not, consumption did not affect the functioning of the board. And there was a subsequent resentment because he had been nominated by two organizations. And what the distinction here is that the position of the deputy president is in a unique position as defined by Articles 130 and 131 of the Constitution. Therefore, that case would not apply. There are many board members, about 8. This is a single position. Does not apply. As distinguished, my lord, as the impeachment of the deputy president under Article 145 and the impeachment of a governor under Article 181 and Section 33 of the County Government Act, which is statutorily underpinned. Very distinguishable. All the cases they have cited are irrelevant on governance. The impeachment of a deputy president is unique and is final under 145(7) because it is constitutionally underpinned and not statutorily underpinned. You can't object or finish. That's all.
My lord, with tremendous respect to the court, we have had the opposition from the
court looks, the court does not accept a situation in which one is, of course, this issue that you are saying, that is saying there is no comeback from impeachment and all this, and that we proceed and swear. My lord, if that were to be the case, then it would mean that impeachment is not the legitimate subject matter of this honorable court. Yet we have had the decisions that they have read themselves from the Supreme Court on the issues of impeachment. My lord, Mr. Mudomi, I'm calling my friend, came with these interesting arguments that on the issues of jurisdiction. My lord, these issues of jurisdiction is an interesting one, as you will see it in a minute. My lord, the first impeachment case that appeared before a three-judge bench was in Kerugoya. Kerugoya seems to favor a lot of impeachment stuff. And it related from the Embu cases. I don't know whether Professor Ugenda was there. It is important to say this with regard to that I actually made the precise argument that my learned friend Mr. Mubobi made about whether
impeachment of the president, because my submission was not that impeachment is generally non-justiciable. Even the authority cited it was about the impeachment of the president, whether that is justiciable.
I'll come to that in a minute. But the point I want to make, for purposes of the argument, the authorities there, for purposes of the argument, those precise arguments were made. There is actually no distinction when you look at the impeachment for Governor under 181, how it is carried out in the release the one of the president. But one of the significant position that I wish to make from that case is this, that subsequent thereto, all courts from Court of Appeal to Supreme Court have taken the position that it was the desire of the Kenyan people that nothing shall be beyond the reach of the court for purposes of giving redress. And that is the basis upon which we have been proceeding. I will end it up there and come to what is more comfortable. Jurisdiction with regard to purported ouster of the jurisdiction of this court with regard to impeachment of the president. My Lord, jurisdiction is actually not given in the manner that they are suggesting. My Lord, even for purposes of the governor, which he says is different, there is no provision under Article, I believe it's 181, that says, or 182, let me just confirm. Yes, my Lord, for purposes of the removal of county government under 181, the issue is, none of those procedures actually say that after you are done with impeachment, you will go to the high court.
May I help Parliament friend, as you do in Parliament? The impeachment
Professor, this is not parliament. So, and he has not sought to help. Please sit down.
I know that tactic. But my Lord, the point I'm making is that even for purposes of Article 181 and 182 of the Constitution, there is nowhere that those provisions say that when you are done with impeachment at the Senate, you will go to the High Court. But nonetheless, people have been going to the High Court on account of jurisdiction as set out in Article 165 of the Constitution, the jurisdictions of the High Court. And therefore, my Lord, these requirements that, there is no provisions for going to court, it is neither here nor there. That is not the design of the Constitution. That question of jurisdiction has been settled by specific provisions of the Constitution. My Lord, what about these issues that you needed to go to the Supreme Court? My Lord, for purposes of the jurisdictions of the Supreme Court, it has been settled very clearly. I believe it is under Article 163, sub-Article 3, and it is settled in a manner that it says in very, very conclusive terms. This is 163. I believe it is 2. It is actually 3 and 4. They completely settle what is within the jurisdiction of the Supreme Court. Their argument that you cannot arrogate jurisdiction would actually come into play in this particular manner if this court were to make a finding that this matter ought to go before the Supreme Court. Because effectively, you would be amending Article 163, 3 and 4 of the Constitution as to the jurisdiction of the Supreme Court. But my Lord, where you find comfort is that the jurisdictions of the High Court, and that's why it is a court of original civil and whatever and criminal jurisdiction, is that the High Court has jurisdictions in everything unless the Constitution says otherwise. And to deal with that, when we come to the Senate, the moment, my Lord, you say the Senate was sitting in a quasi-judicial capacity, it is the design of the Constitution that any person who sits in a quasi-judicial capacity, there is a right to go to the High Court. There is no law in this country, not one, in which any person who sits in a quasi-judicial capacity, there is no remedy to go to the High Court by way of appeal, by way of Article 23, or any other manner. So that issue of jurisdiction is neither here nor there from the plain reading of the Constitution itself. So the other cases of Nixon, all those, they would be neither here nor there.
Dr. Ogada also addressed this, but what is your view on the submissions by Dr. Kindiki about the constitutional history of that issue?
That's very interesting. I think I should say something. I was just giving myself additional pressure. My Lord, for purposes of that history, and incidentally, as a young lawyer, I was involved in all this process, courtesy of Munche, Orengo, and Dr. Gibson Kamal Kuria, so I can speak in past knowledge of some of these issues. My Lord, this Boma's draft constitution, you actually find it very interesting. We cannot go deeply into it. My Lord, the issue that is important to note is that under the Boma, the duty, the standing orders and in the Constitution, as a presiding officer in the National Assembly or in the Senate, the Speaker, there is a duty of impartiality. That is where anything you read about the Speaker, they talk about that. The duty of impartiality for purposes of the Speaker. For purposes of both Speakers, my Lord, they made the rules of impeachment. Those rules are the subject matter of what is going on. How you will carry out public participation, the calls that were made, is it going to be plenary, is it going to be committee? The most important one being, you could have held these proceedings until Sunday, you decided to read the rules, to allow people to vote on issue of rights. My Lord, my knowledge of and Article 27 of the Constitution, matters of rights are not subjected to votes. Yet that is what happened at the Senate. So that's an issue that we shall be talking about when we come to the hearing of the petition. So the Speaker is not a nobody. The Speaker, for purposes of these proceedings as they happen, all those speakers, they made consequential decisions that have had really serious implications in the matters that is before you. Mr. Bumbo, my learned colleague, he says very many useful things. You wonder what to choose, what to leave. One of the issues that he said that is when it was of Article 73(1) of the Constitution. That, of course, will be the case when he reaches the end of the road in these proceedings. End of the road will be Supreme Court, I am sure. But as of now, that issue does not arise. My Lord, as regards the issue of Article 148, 149, I think we have said a lot about it, except, my Lord, when it is alleged that public participation under Article 149 is not required. My Lord, the issue is this. The Constitution is clear that from Article 10, it says whenever you are interpreting or applying the law, the values and principles in Article 10, which includes public participation, shall apply. What that means, if the Parliament is carrying out a constitutional duty,
of the Constitution requiring public participation is deleted from the
I hope this information will serve its purpose.
I think you did answer Senator Council's question.
That decision will actually reverberate through all cases that touch on public participation. It's earth-shattering, and we are happy that God has brought it at this time to us. So God is on our side.
But I wonder now whether it is who was talking about Roscoe Powell. Somebody was talking about Roscoe Powell. But I agree with Roscoe Powell, one of my favorite legal philosophers, when he talked about
views under Article 118 of the Constitution. But ladies and lords, you are invited to look at the trial at the Senate, and you are told that it was time-bound. My ladies, my lords, it's a misconception and misreading of the Constitution under Article 147, 145. My ladies, my lords, the only time Senate was limited was when or if it constituted itself in a special committee. If what transpired in Parliament, in the Senate, was a matter that was under Article 145 clause 6, then we could say that the 10 days period mattered. But it is important for us and imperative for us, my ladies, my lords, to note that when the Senate starts to hear the impeachment of the deputy president, it is such as a plenary of the House. And as such, the 10 days were not therefore applicable in that circumstances. Number two, my ladies, my lords, you've been told that the Deputy President avoided to appear for his defense and that he was represented. But my ladies, my lords, if my good learned friend Professor was guided with the truth, he would have drawn your attention to the provisions of the rules of procedure for the removal of the President and Deputy President, starting order number 78, 9, and you would have drawn your attention to rule number 6. And on that rule number 6, he would have told you that the rule provides that where the President chooses to appear before the Senate, the President shall be required within 3 days of the invitation under sub rule 4 or rule 4 on the date specified in the invitation to file an answer to the charge with the office of the clerk of the Senate, in which the President shall set out. He would have told you the mode of appearance. 1, the President's response to the particulars of the allegations. Number B, how the President, and in this case the Deputy President, proposes to appear before the Senate. And that rule has created through mechanisms or through 3 ways in which the Deputy President would have appeared. 1, whether in person. 2, by advocate. 3, in person and by advocate. The operative word in our case, my ladies, my lords, is number 3, in person and by way of advocate. The Deputy President appeared in person and by advocate. And as such, my ladies, my lords, when he was taken ill, the question of them appearing in person and by advocate was an issue. And number 2, my ladies, my lords, he was a witness, and the only key witness before the Senate. How then could you say that there was fair trial under Article 50 of the Constitution when the only fundamental infrastructure of the trial is unavailable? My ladies, my lords, permit me to address you on what was submitted by Mr. Somane. It's unfortunate that he has chosen to have a very lean and thin way of looking at the application of Article 149 of the Constitution. There can never be anything that is misleading to say that that article should be read in isolation of other provisions of the Constitution. If you choose to read Article 149 in isolation, you arrive at the absurdity that Mr. Somane and his colleagues have arrived at. I would urge this honorable court to look at the import of Article 259 of the Constitution, which provides for the manner in which the Constitution must be interpreted. If Mr. Somane was guided with the truth, he would have invited this honorable court to harmonize and purposely read into Article 149. My ladies, my lords, the reading of Article 149 in a purposive and in a harmonious way would have told Mr. Somane that then Article 99 and Article 197 of the Constitution is imperative. And therefore to say that the IBC had no role in the process of the nomination of Mr. Kindiki is absurd, is not true. The fact is that if Mr. Kindiki was to successfully become the Deputy President of the Republic of Kenya, is it then true that he can become a Deputy President who has not qualified under Article 99 of the Constitution? Is it therefore true that he can become the Deputy President if he has not qualified under Article 137 of the Constitution? Who then determines this qualification? Is it the President? Is it Mr. Somane? Is it I Ndegwa? Who determines that qualification if it is not the IBC?
My Lord, there is something that Mr. Dewey is submitting on, which touches on very critical parts concerning Professor Kindiki as to his qualifications. And we are all familiar with the qualifications of Professor Kindiki.
I think the last time Mr. Kamodo was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to work for the other client because it would have been illegal. but I have a client, so I'm properly on record. And it is important that the record be made straight with regard to Professor Kindiki's qualification, and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kindiki has acceded to. And secondly, it will be
an issue that is being argued. So we're going to have the opportunity to answer it, because the law is the opposite of what you say.
It was raised by Mr. Gilo, just clarifying.
It's
Then
not
Mr.
time
Gilo
to
will
raise
continue.
that issue. That is my submission, my lord. He is going into the merits of the
But then Mr. Gilo may
Just let's sort it. My lord, it's news on record for Professor Kindiki. I think if Mr. Dego Jiro, my very good friend, I usually call him the Black Bull, would keep off rehashing his application.
The black what?
Bull. That's what Dego Jiro means. If my friend the Black Bull would keep within the remit of a rejoinder and a reply, will not be having all these interjections. I've been resisting the urge because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as a person on record for Professor Kindiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Jiro time to.
I am also obliged, my lord. My lords, finally, let us distinguish the Kisi case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kisi, my ladies, my lords, is that the Kisi deputy governor underwent the full trial.
About the one I was speaking to my colleague about was given by this court not so far ago, on the 21st of August 2024, in petition P429 of 2024. Let me come to the other case, the Kisi governor's case. And Lord Justice Ogola, you are familiar with that case, you're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place, and that matter would come before Justice Okwani, which is a decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. My Lord, that case is different from this one on the issue of delay. Under Section 32D of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Moratu do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Moya on 14th of March 2024. So she was coming to court outside the 14 days. My Lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My Lord, if you look at page 233 of the CKRC final report, you find Kenyans speaking about, my Lord, the need to allow the transitional processes to be disputed. My Lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court by the heard. So, my Lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kirera conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. And allow me to concur fully with two things that my learned friends, Mr. Nyamodi, and my good friend, Mr. Somani, said, that conservatory orders are really for the court, because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved here is an impeachment both of the National Assembly and the Senate, and the subsequent nomination of Kindiki to the office of Deputy Governor. And again, unlike Mora, easier to take off here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petition more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders, as tools for preservation of the subject matter, hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Wendy Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kindiki is sworn into office. A lot of other cases we agree with, cited by the National Assembly's Italy Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. The particular state of affairs, which so far you've preserved, is that our client is the Deputy President of the Republic of Kenya. We ask you to sustain the conservatory orders. My Lord, the Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court would remain to the end of the term, it would remain unfilled. That time, we had not yet amended Section 32, Capital B of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable. I reiterate that the timeline we have here is 74 days. We're yet to reach into a quarter of those days, my Lord. And from the posture taken by this court, it's possible to hear this case and conclude it within those 74 days. My Lord, this petition, within those 74 days. All the three chains of Kenyan court, when required, have risen to the occasion. BBI did not last the 5 years my friend Mr. Kiankoli spoke about. It lasted a matter of months. And so it's possible for this court to hold things in place and to expedite the main petition. My Lord, unless that happens, my becoming friend, Professor Gideon Migai, spoke about the dissipation of the subject matter. He said this has already dissipated. My friend, Professor Jenda, said, likened it to a death which has already occurred, and so there's no coming back from it. The Senate, in their submission, suggests damages. The petition does not plead for damages. In short, my Lord, if at this stage the respondents can tell you that the court cannot craft remedies, Dr. Kiankolo bases his preliminary objection on that point. He says that you should not touch this dispute because you would not be able to craft any remedies after hearing the case. My Lord, if at this stage, before you hear the case on the merits, you can be told that What would happen when, without conservatory orders, you hear the case and the petitioners succeed? My Lord, as I move to conclude, the Attorney General urges you to find, on the basis of the vacancies in the IBC, that there is public interest in allowing the process to conclude. My Lord, there is an authority, a court order by this court in proceedings to which the Attorney General was party. The Attorney General, in January of this year, 26th of January 2024, in the Vanessa case, the Abdullahi versus Attorney General, was directed to reconstitute the IBC. He has not done that. Today, the Attorney General stands before you and tells you that on account of his derelict, on account of his and his client's contempt of court, you should exercise your equitable discretionary remedy or conservatory orders in his and his client's favor. My Lord, a party cannot benefit from the ongoing ruling. That fact of vacancy in the IBC against an order of this court should not be evaluated in favor of the Attorney General and to the disfavor of the petitioners. Lord,
are there any pending litigation on the IBC?
There are, yes, my Lord, but this order has not been stayed, it has not been appealed. Yes, my Lord. My Lord, there's a case that we did with my good friend Mr. Adrian Kamodo. It's called Itumbi versus Law Society of Kenya, where Justice Omudi gave directions and orders to maintain the status quo pending the determination of the matter in court. Itumbi, through my good friend Adrian Kamodo Njenga, went to the Court of Appeal. The Court of Appeal, my Lord, affirming those orders, found that it was an act of mischief to ask
Direction on whether persons who are not parties to the application, because there are only two applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Are the two things?
Why are we being creative?
No, the two things on way forward. I think we still have to hear interested parties, or we have that. Anybody? We'll finish with yes, now the right to rejoinder is only limited to the applicant and not any other person supporting the application. So it will go only to the applicant. And in this case we have two, and we'll have how much do you need?
You have given us 30 minutes. I am addressing the court, please. Reply to the court. You have given us 30 minutes.
My Lord, do we do between 15 or 20?
No, my Lord, there is a lot that has been canvassing, but they have given us the impression that they will need less than an hour. We have obviously done 4 hours and something. The worst things that
okay, let us
we can do within 5 minutes.
Let's
or less, depending on how much is able to cover. The only issue, my Lord, that is the mischief is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business and we go.
Okay, this is the way forward. We will give the respondents the time they need. 30 minutes each. Not the respondent, but the applicant. 30. Let's go.
My Lord, may I please the court?
Yes, on what issue?
On the same issue, because I've been standing and I did catch your eye. Still on the issue of the right of reply. My lords, you might remember that I am, first of all, I am one of the unrepresented petitioners in petition 11. And for the
My Lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My Lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications will be had.
Now, Mr. Bosso, just a minute. We will restrict ourselves to the applications at hand. So if yours is not among the 2 applications, then you may have to address that later. And the rejoinder should be on point of law. Rejoinder should be on point of law.
My Lord, I stand guided, but I still wish to point out that there are very specific issues that I raised that were not raised by the other applicants, and which the other side has responded to, and would leave the issues unresponded to altogether.
You can pass those submissions to their counsel for the other applicants.
Before counsel proceeds, I am one Munga, counsel for the 43rd petitioner, Mr. Moraro Moke, and we also had an application with we believe we have a right to rejoinder, brief rejoinder, and it was one of the applications that was reversed. So we also have a brief right to rejoinder. Will only take 5 minutes.
My Lord, Moraro appeared in person and argued his own case.
And I am his counsel.
No.
We appear together with him.
Let us give directions and we will proceed with these directions which my Lord that very much going to give. There must be order in every proceeding.
We'll be starting with Mr. Yes, proceed.
Lord, my name is Ochiel that and it's a great privilege and honor for me to appear before you and to make the Deputy President rejoinder. Ochiel Dudley is my name. Lord, allow me to begin with where my very good friend Mr. Samani stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court
The threshold is not VAT, by the way. The threshold for public participation is even lower because of that decision. And when you look at that decision, which we provided to the court does what we call procedural constitutional compliance. And what is that? You looked at whether a vote happened and the threshold within the Constitution have been made. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, on that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of the, it is the, Lordship, just the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer the
How is it reported?
It is reported as E031. Let me just not reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury versus Okia Omtata. I argue that matter was led by Professor Jim Muigai. Mr. Ochiel, that is there, he can revert, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic quoted the case of International Trade Administration Commission was in South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law. It is a direction to you. And if you look at that case, if you look at Peter Munya, if you look at the nugatory aspect, and if you look at the fact that there is at what the submissions of Marjan Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against IEBC. Because if you told me this is an election you are able to clear, then I'll tell you how am I supposed to conduct this nomination process? And what are the constitutional orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
Oh.
Who has told you to step
No,
down?
I was being told by Professor Gili.
This
My professor is telling me to step down. But if I can, just a second.
Okay, you can step down.
No. But Professor, our submissions are those ones, they are on record, and even if there is a role to be played by IEBC, our position is those are administrative roles which we will still play, and that is provided for under Section 11 of the IEBC Act, Section 13(1) of the IEBC Act. The role that we have to do under 137 is to check the voters register, and we check voters register for even people who, for Kenyans every other day, it's a public document. There's no role for the IEBC to play, and if the court was supposed to make there was a role for us, then we say those are administrative roles, but the court should not find a role for us.
This supply authority you have quoted of E031 to E033 of 2024.
It is hot off the press. I will submit it just now.
Submit to our assistance.
I will, Your Lordship. I will. Thank you so much, Police.
My Lord, I want to apologize if I am here to take judicial discretion from you. It was intended to keep my promise to you that we would not do.
We now get to know that every side has a prefect. This side, the prefect is Professor Gizu.
My Lord,
It's a delicate balance.
Yeah, thank you, my Lord. For the record, my name is Peter Onyama. I appear for the Senate, and for the completeness of the record, the following documents are the responses to the purifying affidavit filed on 21st of October 2024 in petition E015 and 565. And then we have written submissions which were filed on the date of October 2024. And the six out of 5 written submissions, yes, they are all in the system. Allow me to make just some brief remarks to highlight our points in addition to what my colleagues have said. I will start first of all by stating that if you examine the provisions of Article 3 of the Constitution, 23.3, the grant of conservatory orders envisions the exercise of discretion by this court. It is the discretionary remedy. It's a remedy which is not available as a matter of right. The petitioner must lay before court sufficient material in accordance with the threshold which has been laid down to, of necessity, lead the court to grant that remedy of conservatory notice. And it is important then at this point to mention the full scope, the third test for the grant of conservatory orders, as contained in the Peter Gatirao Munya case. The third test, this test is deeply erratic. It's also elastic. The test requires the exercise of discretion. So at paragraph 6 of the Peter Gatirao case, the Supreme Court decision, you will find the following words, which are very, very important in our case. And that's the point I wanted to make in the first instance. That the grant of conservatory orders should be guided by the inherent merits of the case, bearing in mind the public interest. Public interest has been argued by my colleague, I don't need to repeat it. The constitutional values and the proportionate magnitude and priority levels attributed to the relevant causes. That is where I want to focus my submission. The provisions of Article 23 and the paragraph 86 of the Peter Gatirao Munya case are supplemented by the provisions of Rule 3.2 of the Mutunga Rules, which require you to apply the constitutional doctrine of proportionality in the grant of conservatory orders. So that, my Lord, there are two more from this side. Yeah, two more from this side and very short submissions. My Lord, allow me to just make two crisp points.
There's a need for health break.
Yes,
I am informed. Okay. So we resume 10 minutes time.
Thank you, my Lord.
How long? I may request to break at 10 minutes. 10 minutes. I think acha tu.
Ile side tu inaongea. Hiyo side tu inaongea.
Basi hao pande hiyo wametoa maoni, pande hiyo wametoa maoni, sasa hajaje kuchukua wanaandika hizo nini points. Nafikiri kitu wanataka kumalizana mbele.
Sara kwa wapi?
Hapo nje.
Acha nichaje hapa kwa stima.
Okay. Umeenda ama? Nimepause. Zako break. Pause tuendelee sio? So wanaanza kwenye pause. So nisiende mbali. Haya usiende kwa maana nataka kwenda. Kwani tunamka nini? Niko na pesa sasa. Hapo bado tuende mbali. Okay, situzime kama hii. Kama iko tu sawa. Hii ingine. Hebu nishikie hapa. Umechukua? Uko na betri ingine?
Nataka kuchaji simu kiasi.
Eka hapa.
Toa kwa kando.
Simple reading of Article 148, which is what happens in our ordinary elections, does not call for public participation for the position of the nominated person to occupy the office of the deputy president. Now, if we are to agree, and we have seen it in real life, that is what happens. We don't then subject them to public views around what people think about them, sending memorandum. Once that nomination is done, there is no more that follows, other than the declaration after the election itself. Now, why is this important? It is important because of a submission that was made earlier in relation to other provisions of the Constitution which call for public participation. Examples would be in Article 132, for instance, under the functions of the President, Article 132, Subarticle 2, under the functions of the President, the Constitution says, the President shall nominate and with approval of the National Assembly appoint or may dismiss A, Cabinet Secretaries, B, Attorney General, C, the Secretary, the Cabinet in accordance with Article 154, and the Principal Secretaries in accordance with Article 155. It is in that instant that then public participation is called for. So that then, when the Constitution talks of approve, it means give an opportunity to the parliamentarians to also interrogate the person that is to be approved for whatever position we have. In this case, it is a submission that the Constitution says vote, meaning elect this person. And the test to be derived from that is first the poll. In other words, at the point of voting, the parliamentarians vote to support or a majority of them support the nomination. That is the simple question that will be presented before it is, for determination. Permit me then to move on to speak to the place of public interest in relation to this process. Now, it would be expected that pursuant to the provisions of Article 146(2), that when a vacancy occurs in the office of the president, the deputy president shall assume office as president for the remainder of the term of the president. Number 2, that is Article 2B, that if the office of deputy president is vacant or the deputy president is unable to assume the office of the president, the Speaker of the National Assembly shall act as the president, and an election to the office of the president shall be held within 60 days after the vacancy arose in the office of the president. What is the public interest question? The public interest question is, it is expected, it is a legitimate expectation by the people of Kenya that they'll have a president. In the absence of a president, they will have a deputy president. In the absence of a deputy president, that will have a situation where the speaker would be able to steer the country into an election. The public interest question that we want to ask or present to court, would it be in the interest of, now that it's clear that there is no occupant of the office of the deputy president, would it be in the interest of the public to expect or to push the country to a potential election under this article, because we want to issue orders that would stay the filling of that office? In our understanding, my lords and my ladies, that would be pushing the Constitution a little too far. It should not be lost on us that this same petitioner, the mover of this very petition, during the discussions around the motion itself, we had terms like Upa Dereva, Upa Makanga. What stops him from filing yet another impeachment motion against His Excellency the President tomorrow? It shall be processed. If it is processed, we'll have walked straight into a constitutional crisis. Now, that militates against public interest. And they're saying crisis because we live in this country, and we know that, as a matter of fact, we do not have a duly constituted electoral commission. Even if it was the case that we have a deputy president as of today, then pursuant to the provisions of, again, Article 134, which speaks to temporary incumbency, such person would not be able to appoint the electoral commission. What then does that mean? It means, potentially, that the first person to get to Uhuru Park and get sworn, who will be the president? My lords and my lady, is that a position we would want to allow the party to get into? I might need to add by saying this, that these constitutional principles are exercised within a particular context. It is a political context. Political context, by its own nature, and I had my learned friends speak to the fact that we live in a constitutional democracy, is a competition. In that competition, there will be those who will be for one party and those who will be for the other party. Naturally, it follows that when one party loses office, there will be some measure of discomfort. What then does the court do? It is in those occasions that the court rises to steer the country through that process, so that then the competing interests are balanced in a way that ensures the stability of the country. And because it's very interesting and very, something to be very proud about in Kenya today, that we are talking about such sensitive issues in this sort of civil environment. My lords and my lady, in other places, when we talk about this sort of transitions, these are constitutional transitions, they end up subjecting the populace to more difficult positions. Now, because we have this opportunity, what then would the court be considering in whether to grant the orders that we sought or not? My lords and my lady, the constitutionality speaks to something we call utilitarianism. Utilitarianism dictates that the court helps maintain what I would call constitutional homeostasis. That means that we then ensure that whatever decisions we take is such as to ensure that there is stability within the country and that the country is given an opportunity to move on. My lords and ladies, these are jurisprudential discussions that have found favor with those who have been there before us. We've been told in our learning of the jurisprudence about Jeremy Bentham, about Arthur Stewart Mill. They were great proponents of utilitarianism as a concept of constitutionality. May I also invite you to the works and findings of Roscoe Pound, who postulates that the law is supposed to be a tool of social engineering, and that then, in its implementation, that social engineering is supposed to help to bring stability within the nation. My lords, my ladies, it only follows that for us to achieve that stability, then the orders that were issued and that there are experts are orders that are supposed to be set aside. The country allowed to move aside. I am most glad.
My Lord the Presiding Judge, as I sit down,
to the extent that it is not contemplated that the person who has been impeached will therefore be able to run or even express interest for nomination for purposes of Article 149. Let me then take it one step further to relate Article 149 and 148. In particular, let me start this conversation from one step behind. Our Constitution at Article 1, Sabbatical 2, speaks to how our sovereign power is to be exercised. In particular, it says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now,
those are the values, my Lord. I would suggest you hold them close to you because of the referring to them shortly. We have in addition filed written submissions, skeleton submissions dated the 27th day of October 2024. Before I delve into the PO, my Lord, a suggestion was made to you. I had forgotten to tell you, my Lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my Lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my Lord, is that unless I am mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me while we have raised this PO, and you find that I deserve to be laughed at, it's okay. My Lord, our PO makes only 3 interrelated points. The point number 1, which you will find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about the enforcement of the Constitution to confirm whether anything. I'm here to tell you very shortly, my Lord, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the president and the deputy president. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the president or the deputy president of the republic. And that is the point made in paragraph 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the president and the deputy president. But if we are wrong in that submission, my lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. So why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lord, are set in paragraph 6 of our submission. And the simple point is this, that our Constitution denies this court, the High Court jurisdiction, on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone was to come here and say that he was denied his Article 38, which is the human rights under that election. My lord, it is clear by dint of Article 58 sub Article 5 that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My lord and friend, Mr. Ngwe talks of the word decency. We are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear. If you have a dispute as to that matter, never mind that it has abrogated the entire Bill of Rights, the court you go to is not the High Court, it is the Supreme Court. And property is a matter of the Bill of Rights, Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my lord, I'm here very humbly to tell you, the mere fact that someone has run to you screaming Article 23, Article 165, does not, without more meaning, that this court has jurisdiction to hear that matter. In other words, my lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about Kindiki. So the substratum of the dispute before you is impeachment. And our point, my lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which reminds me of Professor Gidu Muige's issue about his disability, then you have no jurisdiction. Luckily, my lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you. Which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bible, my lord, the Bible of Authorities. We have produced, rather before you, extract of the Burma's constitutional, the Burma's draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether this matter should be handled in the court and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other.
Right into my submissions. And I will demonstrate, my lords, that contrary to the submissions made by my learned friends, Articles 47, read together with Articles 50 and Article 25 1C on the right to a fair hearing, were complied with. And I will show, my lord, that as of the time that notice was received in the Senate by the Speaker on the 9th of October 2024, notices were issued to the petitioner to file all the documents as prescribed and to defend himself to every question that was raised in the National Assembly, which, my lord, you recall, had voted by 282 members to impeach the deputy president. The right of fair trial, fair administrative action under Article 47, and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted and the dates when the deputy president would be heard, and that would be Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged and commenced, and all parties were aware that the Senate investigation would take 2 days. Your ladyship and my lords, parties were then invited to respond to every allegation. This was a two-tier trial, my lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no-brainer. The Senate, as a trial chamber, my lord, Articles 94 and 95, donating powers to Senate and to the National Assembly respectively. The Senate then proceeded to afford an opportunity. And I want to just demonstrate, my lord, that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1. Because the people may either exercise their powers directly or through their elected representatives. So my Lord must read the Constitution in the sense that the Constitution then, speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My Lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question. That the petitioner participated in the entire trial. Only the petitioner, my Lord, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented this case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body. Each senator, considering the allegations and bundles served to every senator prior to the trial. My Lord, it was on the 17th, and this is an important distinction. At 2:30 p.m. after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mwiti presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness, but did not read it. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. My Lord, there's a curious point here, and this is important, my Lord. The provisions of Article 145, 5 and 6, and I want to refer to those articles, provide, my Lord, that at an impeachment hearing before Senate, a party may be represented. 145.5, the President, the Deputy President, shall have the right to appear and be represented before the Special Committee during investigations. This article was wholly satisfied because the Deputy President was present throughout the trial. My Lord, then Article 145, 6, A and B then step in. If the claims have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. My Lord, Senate accorded the Deputy President an opportunity to be heard. How was that accorded, my Lord? That was accorded, my Lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my Lord, he was present during the entire presentation of the case to the National Assembly. But third, my Lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My Lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submission, and it goes like this. At 5 p.m., my Lord, the Deputy President, the Counsel for the Deputy President, Senior Counsel Paul Mwiti, submitted to told Senate that he could not trace his client, but that he had been admitted at Karen Hospital. He neither presented a medical report nor a report from any doctor. And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the Deputy President, my Lord, Counsel and his team, Senior Counsel Paul Mwiti, Eminent Counsel Elisha Ngoya, and the entire team proceeded to walk out. And why did they proceed to walk out, my Lord? Perhaps they did not read the wording of the Constitution and or the standing orders. Because a party, my Lord, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my Lord, every opportunity was presented to the respondents to present, but they opted, my Lord, not to proceed
and not to provide any document to say at that point to, my Lord, confirm, my Lord, at the point that their client or the Deputy President in that matter was unwell and admitted. Senate then proceeded, my Lord, to vote on that question. My Lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my Lord, under Standing Order 85, senators on a procedural motion may vote by acclamation. That vote was carried and Senate then voted to proceed. My Lord, the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we had to proceed, that Senate proceeded, my Lord, the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time-bound and were to conclude in 10 days. The last day, my Lord, that the proceedings were to conclude was the Saturday, the next day. My Lord, unfortunately, Senior Counsel Mwite and the Hansard will demonstrate this, my Lord, had applied for an adjournment to the following Tuesday. My Lord, we have demonstrated that the petitioner dragged the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court for in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disaster. My Lord and Your Lordship, the petitioner had taken part in the cross-examination of all the parties. No case, my Lord, has been presented before you that one, there was a violation of the standing order of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were preferred against the Deputy President. My Lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend, Mr. Masharia, made before this court, that there was additional evidence that was entertained by the Speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my Lord. My Lord, that was a substantiation of a charge on economic crimes that failed. Only, my Lord, 5 out of the 11 charges proffered against the Deputy President petitioner hearing succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my Lord. That out of the 6 charges, my Lord, the Deputy President was convicted on the gross violation of Articles 10 to AB 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is laid before this court, my Lord, that is on violating this code that requires him to undertake certain functions and undermining the function of the National Security Intelligence Service. Ms. Timodo of Timodo and Company Advocates would want the Deputy President to apologize on that count. That's a live matter. But my Lord, in the grant of conservative reporters, I submit, and this is because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority. Yes.
And I was with you, Professor.
My Lord,
Professor, we have
in the principles that the court considered, the Supreme Court considered in the Munya case, public interest, I think on the scales, weighed highest.
that this court must take into account the import of a conservatory order issued ex parte against public interest. My lord, this is a country that is built on the Constitution of Kenya 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 of the rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the deputy president, my lord and my lady, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a deputy president sworn in because of the dictates of Article 131 of the Constitution. My lady and my lord, a conservatory order is therefore inconceivable in the terms defined in the Bunya case. A conservatory order of the nature issued by Justice Mwongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect Meru. This court would only use that authority to support the appointment of His Excellency Honorable Professor Kindiki, so that this country moves to the second level. I would urge you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic. My lord, wherein his remedies lie, the life friendly body will submit. If it is a salary of 1 month, that would be compensable by damages. If it is a week salary that is 6 that I should have been or to have been Deputy President, that will be compensated in monetary. But this country, my lord, cannot be at a standstill and be held through litigation, because we need to have that position free. My lord, if I move to the other point, my lord, we have submitted that since every opportunity was afforded to the Deputy President to present his case, and that he failed to present his case, my lord, every argument before this court by Malande friends on the import of the processes of an impeachment fall on their back. They fall on their back, my lord, because the authority in my movie Sonko and Nairobi City County Assembly, and again I argued this one. In fact, I was in this one. In this case, my lord, the impeachment was upheld. In this case, Michael Mbuvi Sonko had sought to halt the process leading to the impeachment because there were no reasons given for the impeachment. The Court of Appeal rightly stated that 1, there was the Hansard that contained reasons. 2, my lord, in terms of an impeachment, my lord, Mike Mbuvi Sonko was challenging the approach where the Senate sat as a whole, as a committee. The court finding that that is an option that is open to Senate and cannot speak to the lawfulness or otherwise. Council on the other side submitted that there was need for a committee. Senate, in its proceedings, my lord, in its wisdom, had voted to proceed through the whole house and accorded the petitioner all his rights that were due to him at the initial stage only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My Lord, we submit, my Lord, that unless the processes of Senate are faulted by my learned friends, that impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, Rigathi Gachacha, stood impeached henceforth. Unfortunately, my Lord, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. And that is why we have the law of succession. Rights and remedies then come into question. My Lord, set aside the conservatory orders. Let us move on, my Lord. The bigger public interest tilts in favor of the appointment of His Excellency Professor Kindiki. A very good night. Thank you. Thank you.
President of the court, the members of the court, we are happy to reply to our colleagues. Somebody has come from the woodlands.
My name is Masongo. I'm here for Australia alongside John Marie.
I'm on high demand, so I beg to leave the court. I'm going to take to someone else.
Just a clarification, last time Dr. Minua made an application for Sharia to join, and then you joined
Yes.
My name is Musongo. Thank you so much. The Lordship and the Lordship. As to the Sharia, our slogan and motto is that we care. Our intention at all times is to uphold the Constitution and ensure justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, not 50 years, but I do stand on the shoulders of giants working there before me. And I want to just bring out 5 points in my experience. Why you shouldn't vacate the order or fail to ensure there is conservative order. Number 1, in promoting justice and the interest of justice, we have petitioners who are saying that the right to fair trial and constitutional rights have been contravened and violated. And it will be so painful for them, genuinely speaking, that conservative orders be vacated. Then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal placement. Our argument is that the Lordship and the election to ensure that their constitutional rights to fair trial, even including during this process, just preserve the few days that you guys will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest. My apologies. My apologies. The Lordship and the leadership. need competence, genuinely, and for stability that, for sure, status quo be maintained, not only for the current president, vice president, or even the nominee of the president, because you know it said, ukiona cha mwenzako, kitu cha mwenzako kimeelewa, chako kitie maji. It is critical even for future vice presidents, deputy presidents, to have their rights safeguarded, and at least the court provides a guideline on how Article 145 is to be exercised. And for sure, we also think that and argue that procedural integrity and legal principles that you are at this point making, the lordship and the bench, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately when now you make a finding that for sure the entire process could have been flawed. We argue that to also avoid arguments that possibly there would be potential bias, we encourage the lordship and the leadership to really consider that as a wind up, that let's ensure that there are no allegations from both sides that justice is not done. It's imperative that at all times justice is still to be done in line with Article 159. And lastly, they are arguing, the petitioners, that irreparable harm would be occasioned upon them. And it is in the interest of justice that they be accorded that one final bullet, that chance to be able to benefit their rights before the final outcome of this one. I humbly pray that the lordship and the leadership please do not forget their rights. Thank you so much.
Thank you very much, Presiding Judge and members of your court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may very well use half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are. That's where we need to start. What are the facts that are relevant to you determining whether conservatory orders should continue in force or should be vacated? It is my humble submission that the pertinent, the material facts are as follows. On the 17th of October 2024, the Speaker of the Senate gazetted the removal from office of the former Deputy President, the Honorable Gachacha, by dint of Article 157, Article 7. It is important for us to go there, my lord, and it will take half a minute. What is the language of 145, Article 7? It is this. If at least 2/3 of all members of the Senate vote to uphold any impeachment charge, any, the President shall cease to hold office. That's the language. Shall cease to hold office. As at the day and the time and the minute that Senate voted, the Deputy President ceased to hold office. I hope this doesn't disappoint my learned friend Teresia Kimodo of the Rasiat Komodo and Company advocate, he wants an apology. The deputy president ceased to hold office. But something else happened. An intervening fact is that on Friday, the 18th of October, via a special sitting of the National Assembly, the Honorable Professor Kindiki Kipure, pursuant to Article 149(1), having been nominated by His Excellency the President, was confirmed by the National Assembly and voted on his nomination. One person has ceased to hold office, another person has been appointed, has been nominated, and the body entrusted in law in affirming that nomination did so. That was at 1:30 p.m. on Friday the 18th of October 2024. What then did the honorable judges of the High Court of Kenya conserve? What were they conserving? There was nothing to conserve. In the logic of the law, we've been told that, a lot about why the Constitution is very important, why it's very special, why it's very transformative, why it's not like the Constitution of other countries. It may very well be all that. But the Constitution is a law to be interpreted the way we interpret all law. When we read a will, we don't start searching for the spirit of the will, because the will is speaking. It is saying, I leave my assets to my son, to my daughter, to my uncle. So a person reading a will doesn't tell the family, before we leave the will, let us capture the spirit of the will. If we read a tenancy agreement, we do not say, let us capture the spirit of the tenancy. The tenancy agreement is speaking on its face until there is an ambiguity, which is the same thing with the Constitution. It says what it says until there is an ambiguity. Where is the ambiguity when the Constitution has said, shall cease to hold office? It is our first submission. There is no ambiguity. There is no reason to search for any other meaning, any other spirit, any other constructiveness. The honorable, the petitioner, is aware of that. There is an affidavit here called supplementary affidavit in support of the petition. What does it say in paragraph 22? In this case, however, Kindiki was disqualified because he had not been a member of UDA political party for 3 months preceding the nomination. He was ineligible for nomination to the elective position of deputy president under Article 37 on the 18th of October 20, when the vacancy arose. This is not the Attorney General's affidavit, it is the petitioner's affidavit. So that his lawyer may be acting contrary to his express instructions, because he has sworn an affidavit in which he acknowledges that that office became vacant. It is our second submission that when the so-called conservatory orders, and my colleagues will demonstrate that these are not conservatory orders, these were mandatory injunctive orders of a nature not contemplated by the Constitution in this assembly. At 1:31 p.m., when the conservatory orders both were issued both in Kerogoya and in Nairobi, there was nothing available to conserve. The substratum of their complaint had been overtaken by events. And so much so, my lord, that, and my learned friends will take you through this, there are several judges who were approached to give conservatory orders, including this bench. And you say there are matters here already overtaken by events. That news may not have reached other parts of the country. Very briefly, I will ask you the public news. My lord, this constitution is a constitution to protect everybody. Sometimes it is cited as if it was tailored only to protect a section of the society in Kenya. It is for everyone, including the institutions that it establishes. It is to protect the judiciary. It is to protect the legislature. It is to protect the executive. We are told continuously that the executive is a problem. The executive is a problem. The executive is also protected by law. The president has a power donated by this constitution to nominate a deputy president. He did that. He has the power to send that name to court, to parliament. He did that. Parliament has the power to vote on that name. It did that. But it is being suggested that that in itself finds no protection under the Constitution. What finds protection in the Constitution? Impeachment process is a special process. It's sui generis. It is neither civil nor criminal. It's a process sui generis. That is why, and this cannot be said many times, enough times, that is why the framers of the Constitution do not say that the Vice President will be brought to the Supreme Court of Kenya and tried for violations of the Constitution. It is a political process. It goes to a political chamber. Senate sees it as a political body. That's what happens in there. When Dr. Kaminwa says impeachments are never successful in the United States, it is because of the peculiar politics of the United States. Because the impeachment process, even there, is more political than it is. So we must have fidelity to law, my lords. It is our submission. If you read through the case of Kirero Nguge, it is in our bundle, and I will not. And if you read the case of Martin Wambora, Kirero Nguge is instructive. This is what the court said, and I will be very brief. A court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. Thirdly, the ripeness doctrine. Actually, much was said about justiciability. This is not new law. This is old law. It is thousands of years law. Thousands of years of English law. The first thing the judge would ask is, what is your course of action? You must have a course of action. The court is not a forum where litigants can hold an academic debate. The judge will always ask, what is your course of action? Okay? Now, so the doctrine of justiciability may sound new, but it is as old as the common law. What is the political question doctrine? We are not going to argue it. But it is actually straightforward that the Constitution recognizes that it has donated power and authority to several institutions. And each institution should keep to its lane. We have developed a constitutional constitutional law, or we are developing a constitutional law here, that actually is that actually invites contravention of the Constitution. And it is this, that every conceivable social, political, cultural, economic grievance is capable of a constitutional resolution. How is that? How is that? It is not possible. And that is why in our political social system, we have a million other ways of resolving conflict. Not all conflict is justiciable. Not all grievances are amenable to a constitutional solution. Now, let me go on to my second last point about I want to take you to the case of county government of Kisi and two others versus the Independent Electoral Commission. It is a 2024 decision. This is the last thing I'll say before I invite my colleagues to come in. The gracious lady will not have to bow her gong. This is what the court said in that matter. While guided and applying the foregoing, in this case, the law does not anticipate that the office of the deputy governor shall remain vacant indefinitely for whatever reason. Having so held that gazettement is a mere administrative formality, and taking into consideration the circumstances of the instant case, whereby nomination and approval by the County Assembly of Kisi was undertaken way back in April 2024, it would be unconstitutional to further delay and postpone indefinitely the filling of the vacancy of the office of the deputy governor of Kisi. That's what that court said. Finally, because I'm still within time, the Wajir case shows that our constitution has self-correcting provisions. What happened there, my lord will remember? Yes. Is that the governor had been impeached. During his impeachment, the deputy governor assumed the high office of governor. He went to court. After a long litigation, the court found his impeachment was wrong. And then the court said, reverse the order. Just to use an expression by my learned friend, I think it was Mr. Kibago, the law is organized. The heavens didn't come down in Wajir. The law said, go back to your office, and the rest of you go home and do something else. That is how to ensure certainty, predictability, stability. That is what we should have here. We are here. I am told on behalf of the Attorney General to assure you that for as long as this matter is litigated, the law will be observed. If a day comes when anything needs to be reversed, that will be reversed. But for now, the public interest is in continuity. Thank you.
Yes, my lord, the leadership of
come up at half past 4.
I had you to say that
Half past 3. It is now 20 minutes to 3.
That's right.
So we can come back at half past 3.
Only one thing, Your Lordship, that we still have interested parties who might want to support the application. You indicated that it's from the establishment responsibility.
There's no problem. We are coming back at 10, at half past 3.
looking for the quorum for E565. Kindly, we have the quorum for E565. Please go
Polepole tu ABC kwa sababu hata sitaki ofredi Umekuwa wapi leo? Umekuwa bigo wapi? Wacha kamera hapo. Ulikuwa wewe ulipata ile nini ya media council? Invitation. Jana. Nilikuwa leo. Sinaisha kesho. Utatuangushia vitu. Umeenda? Sasa nikuulize mimi.
I will speak very briefly. I will take only 5 minutes. Proceed. We will do it right away.
We will be disadvantaged slightly with Mr. Moka's application because he has filed written submissions that he only served on us late last night and we have not responded.
The submissions I filed, they raise the same cases that we all know about. That's the case of the Tirao Munya, which I believe we are sufficiently aware of. Your Lordship, as you consult, I would like to add that even
please don't disturb us.
All right, well, sorry.
We have consulted and we proceed to submission in 5 minutes on points of law.
These are the directions you are giving. Mr. Omoke, your petition, we give directions that has been consolidated with the petition before the court. But the fact of consolidation does not mean that your application will be hard. However, because your application raises the same issues as the application before the court, we will give you 5 minutes to canvass that application. And after that, we will adjourn to come back to consider the rest of them. Thank you.
Thank you, Your Lordship.
I know I have a problem. I represent, I'm holding a brief for my own friend, Mr. Ashford Muluki. He represents a political party, I represent a political party by the name of Maendeleo Democratic Party. And we filed an application, and my understanding was that Mr. Mbuko we had today. I wanted to check that into account. Maendeleo Democratic Party.
Which petition is that?
The authority petition is a motion application.
In which matter?
Yes, it was joined in the
one.
E565 2024. Maendeleo Democratic Party. Well, I understand that you will hear me, so probably I should not waste your time.
Maendeleo Democratic Party is not a party in any of the two cohorts. It's not a party in any of the two cohorts.
I see. That's interesting. I've got to find out. I will start.
Okay, Mr. Mo.
May I say something again, my
Camila, you know you appear in cohort 1 in your own right.
Yes.
Remember that. So if you want to submit in your own right, we will allow you. But for the person who are holding whose brief, you don't appear to see where.
I think I told himself. I don't know.
Just look for him so that he can complete his case. But in the meantime, let's have Mr. Omoke.
One final word, I like being human, and I like taking care of the interests of the judges when they are sitting. You are human. Why don't you adjourn tomorrow? No, I'm being human. I know you are working very hard. Also, I'm saying, can we start tomorrow?
My lord, I think the cat is coming now out of the bag.
Mr. Omoke,
what's cat now?
I would like to indicate that I support the application of the first petitioner, and also submit in support of my own application, which is dated 9th of October 2024. I wish to learn the affidavit, sworn on the same day. My submissions filed yesterday, dated 27th of October, the list of vulnerable authorities. In summary, I would like to state my, Your Lordship, Your Lordship, Presiding Judge, Your Lordship,
what's the date of your submissions?
27th of October. I confirm that I personally attended the public participation at Kiambu Social Hall on 4th of October. And that, from what I observed on that day, I was convinced that I had a responsibility to come before you under Article 3.1 to defend and protect this Constitution. That there are serious violations which this court must consider, and in line with the Tirao Munya case, there is public interest at stake, There is an inherent, there's a case that we need to consider here, where we must look at all those issues of public participation. Was there public participation, not just on the day when the Parliament was conducting it on 4th of October, but even prior to that, under Article 10, I call upon this court to issue the conservatory orders so that we can have an opportunity to re-examine Article 10, which for a long time has been seen as though it is something that is aspirational. And I would like to urge the court to consider this to be something that is binding on all persons and all state organs. So it's such that for the move of the motion in the National Assembly, at the time he was seeking to bring that motion before the National Assembly, he actually was bound by Article 10 to observe all the values contained there, including public participation, go around the country and speak to the people. And I'm here to tell you, my lords and my lady, that the people of this country are angry from what I observed on that day, on 4th of October. And they are sick and tired of how the Constitution is being violated.
Well, as counsel is testifying, maybe he can take to the dock so that we can all have an opportunity to examine this testimony that he
Yes, in response to Professor's objection, I am a party personally, and I saw an affidavit, and I made all those amendments there. And if I'm required to be examined, I'm very much happy to do that, if you require that. So perhaps Prof can confirm, and I'll take the dog, very happy. All right, so I'll carry on. He has agreed that he wouldn't like to examine me, so I'll continue my presentation. Actually, at that very same public participation, I did meet some of the people from his famous home, Rubelli, otherwise known as Danbury. And they were very, very unhappy with the way the process was being conducted. And that's why I've come here, not just to speak for myself, but also for all of these people. I would like to tell you, your lordship and my lady, I'll close my presentation here because I know that we have an opportunity to examine these issues at a later time.
Thank you. These are the directions of meeting. It is now 20 to 3. Yes? Yes. So we can take 45 minutes. John, I want the assurance that we are coming back for the respondent's case.
Yes. Your lordship, that's not correct. My name is Moraro Moke, counsel. I'm the third petitioner. I'm the third petitioner, and I understand from your direction on Friday that you will hear all applications for conservatory orders. I'd like to begin with that issue.
Which one is your application?
My application is to be found in petition E057 of 2024.
But that petition is not consolidated.
Hello? It is consolidated, your lordship. The petition was consolidated by an order that was submitted to me on Friday by the deputy registrar, indicating that the 2 additional petitions have been consolidated. Can you kindly confirm that?
I informed all parties that we continue to receive petitions in this matter. We received petitions as late as yesterday. And by the agreement of those petitions, they seek invariably the same orders and the same prayers. But when a petition comes, after we have given directions on other petitions, certainly you don't expect us to go back on the petitions which are not before the court.
Your lordship, if you allow me to read the order that I was given, perhaps it can share more light. Yes. The order said that application have been consolidated and are required to follow the directions issued on Friday in the other petitions. That's what the order says.
My lord, unless I'm mistaken, we were here to hear applications, 2 applications in petition, 1 in petition 522, 1 in petition 565. Equally, we were here to hear 2 applications from this side that my lord directed will be treated as responses to the applications on the other side. If my colleague's file has been consolidated with this file, it does not necessarily follow that his application also has been scheduled for hearing today. And lastly, my Lord, while I'm on my feet, I know we started by giving directions and the court being fair and allowing the parties to drag on and on. But we are concerned on this side that unless the court is able to fix a stop at some point, the other side is committed to proceeding on and on, as I said, until donkeys grow on. And
we object to that. We are not, Mr. Omoke.
I'm from Vihiga, and I'd like to.
Also, we'll just ask for only 5 minutes, please.
Lord, I will do my best, but I promise I will not repeat anything that has been said. My Lord, I'll go straight to the points. One, what is on trial, or what is at stake in the setup of an interim conservatory order? My Lord, I'd like to inform the court that what is on trial is a Bill of Rights. Article 38 of the Constitution provides that a person has a right to vie and be elected for office, and if elected, has a right to hold that office. My Lord, that is one of the things that is on trial, but I will ignore that for now. What is at stake, because the conservatory order is supposed to preserve the substratum, is the right to a fair trial. My Lord, the components of a fair trial include the tribunal that is independent, it includes the process and the outcome. My Lord, the outcome includes the remedies that are available by law to the individuals before the court. One of the remedies, the material remedies that the parties before this court are seeking is reinstatement of Deputy President Gachacha to office. Therefore, and I will demonstrate when I talk about the Wajir case at the end, that once a new person assumes that office, that remedy is completely taken off the table. And that means these conservatory orders are actually at the heart of a fair trial. And a fair trial is among the rights under our constitution that cannot be limited. It is not that a fair trial is absolutely not limitable, but that the state, through its action, or any person through their deliberate action, cannot limit the right to a fair trial. Why do I say this? During a trial, the witnesses may die naturally. COVID may happen and cases are delayed naturally. That is extrinsic and it may affect a fair trial. But the court must never do anything deliberately that would impede a fair trial or that would be imputed as limiting the right to a fair trial. So, my Lord, by lifting this conservatory order, you will be actually limiting the rights of the petitioners to a fair trial by taking away a very material remedy to the remedies that are available to them. I'd like to talk about what is the place of the Bill of Rights under our Constitution and the concept of public interest, because it has come up very much. Now, our Bill of Rights under our Constitution is very fundamental. The Bill of Rights, the chapter on the Bill of Rights, is the only chapter under our Constitution that has its own doctrine of interpretation. And the Bill of Rights is enjoyed individually as per Article 19, is by individuals. It is actually antithetical to the concept of human rights and individual human rights to say that the Bill of Rights will be enjoyed at the behest of a public interest. They are actually specified there expressly, especially to be enjoyed in spite of the public interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24. And I would have read the entire article for us to see. But what the provisions that it provides is that the Bill of Rights will not be limited except by law. And then only in a manner that is reasonable and justifiable. My Lord, the public interest that has been propounded by at least the response by the Attorney General, or the application that by the Attorney General, did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My Lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My Lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it can actually be justiciable or it's justified within a democratic society. My Lord, I saw in the response by the National Assembly, the public interest has been a bit defined and has been stated as the fact that we do not have an IBC. My Lord, that is not a legal question. The other issue was that we cannot stay without a deputy president. My Lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my Lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IBC is a political crisis. A political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My Lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IBC if really there is a political crisis. Finally, my Lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case. Because they kind of explained how conservatory orders ought to be interpreted. And my Lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my Lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time. Because one of the things that is considered by all parties in this case is that an impeachment did happen. And it's presumed to have happened locally until this court finds that it did not happen locally. By that, the Constitution is very express that the office will fall vacant. And so that one, however much a court attempts, it cannot constrain an edict of an imperative of the Constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my Lord, I want to talk about the Wazir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wazir case relates to a governor who was impeached. The deputy governor assumed office and then even nominated a new deputy governor, and then later on, the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My Lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the 2 cases. In the Wazir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is a question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the holding of BBI, in the BBI case, the presidency is absolutely immune. No amount of court order will be issued that will be able to be enforced against it. Because who will enforce the court order declaring the office of president vacant? My Lord, it's the political arms of government that can deal with that, and that might be one of the issues that are political questions that the court cannot really address. So, my lord, as far as the office of the deputy president is concerned, such an order cannot come from this court. We cannot allow the conservatory order to be lifted, and then we imagine that we will be able to enforce an order removing Professor Kindiki from office. My lord, thank you very much. I'd like to ask my co-petitioner. I think they should.
I wish to make an application and article.
Just be making some remarks on the two applications for setting aside of the conservatory orders, starting with petition number 565. And looking at the prayers that are sought, that application is not. That application is not. I say so because the substantive prayer, prayer number 2, was that pending the inter partes hearing of this application for setting aside that the orders issued by Justice Chacha be valid or set aside. Lord, we already passed that stage, and therefore that prayer is not available. Then prayer number 3, that in the alternative, this court be pleased to set aside valid or discharge the ex parte orders issued on 18 October 2024. Followed those orders lapsed on Friday, that is the 25th of October 2024. So just to make the court work easy, there will be no need to consider that application. Having said that, and in view of the previous directions, that this application will be treated as a response to the application for conservative orders, I would just like to make 2 or 3 remarks with regard to the content of that application amount. And I would just like to mention that paragraph 7 of the supporting affidavit sold by the Solicitor General. Actually, it is in the ground, but then it is reflected in ground number 7. It says, Article 1 of the Constitution provides that the sovereign power belongs to the people, and that there is a conflict between public interest and private interest. The scales of justice to tilt in favor of the public interest. To that, my remark is, the question that is before you is not about a private right. It is a more elevated constitutional question of impeachment of president or a deputy president. Again, paragraph 8 states that the Constitution does not envisage a vacuum in the office of the deputy president, and as such, it is in the interest of justice that interim orders be stayed valid or set aside. My Lord, Article 149 and Article 150 make very clear provisions on the vacancy of the office of the deputy president and how that is treated, even about the vacancy in the office of the president and how all that is dealt with. The Constitution is self-sufficient with regard to that.
Nomination of the second interested party.
First of all, it's both, and I would want some protection for it to conclude, so that we are all fair. They will have the time to respond, and I will not interfere with it. My Lord, so that the important scenario that we must seek to avoid is a situation, and this is matter. It is also a matter both of the Constitution and statute. My Lord, the issue is that if we get ourselves into a situation in which the Honorable the Chief Justice might have to preside over the swearing in of Honorable Kindiki while this petition is pending, my lord, that, to borrow the words of Honorable, my friend, Senior Counsel, would be the greatest absurdity that we can encounter. Why is it an absurdity? It's an absurdity, my lord, for the simple reason that one of the authorities that we have cited is the Assumption of Office Act, where, because of the experiences that this republic went through in the years 2007, 2008, specific laws had to be made to ensure that not only that will this event be a public event, that's number one, but the more important issue from the standpoint of law is this, that before we get there, all legal disputes, contestations over the right to occupy that office would have been resolved. And my lord, that is the reason precisely why they say, after the Supreme Court has confirmed the validity of those two positions, then you do the swearing. My lord, it would amount to taking us back if that aspect, that rule of civilization, were to be taken away on account of the setting aside of the conservatory orders that were issued and for very good reason by your brother judges. I don't know whether there was a system by your brother judges. So that, my lord, the issue, as far as we are concerned, that is an absolutely important issue. We go to the next important issue, public interest. My lord, public interest has been defined in very many cases that are before you. And my lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing. Because we actually have a transformative, one of the best constitutions in the world, for the simple reason that we wanted to be a good example across the world as a leading constitutional democracy. And as a leading constitutional democracy, the issues of public interest is placed at the heart of our constitutional order. I go, my lord, to the definition. This is the only long passage that I will be reading. And this is, I gave the supplementary authorities earlier. This is in the famous case of Murugaro, Christopher Darabi Murugaro versus Kenya Anti-Corruption. This I'm citing the passage appearing at page 7 to 8. My learned senior, Gebu Muigai, will be familiar with this decision. My lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it said as follows. Lastly, before we leave the matter, Professor Muigai told us that their strongest point on the motion before us is the public interest. We understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Muigai is this. We recognize and are all aware of the fact that the public has a legitimate interest in seeing that a crime of whatever nature is detected, prosecuted, and adequately punished. But in our view, the Constitution of the Republic is a reflection of the supreme public interest, and its provision must be upheld by the courts, sometimes even to the annoyance of the public. The only institution charged with the duty to interpret the Constitution of the Republic and to enforce those provisions is the High Court, and where it is permissible, with an appeal to the Court of Appeal. We have said before and we repeat it. The Kenyan nation has chosen the path of democracy. Our Constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. A dictatorship, on the other hand, might be quite efficient and less messy. In a dictatorship, we could simply round up all those persons we suspect to be involved in corruptions and economic crimes and simply lock them up without much ado. That is not the path Kenya has taken. It has opted for the rule of law, and the rule of law implies due process. The courts must stick to that path, even if the public may, in any particular case, want a contrary thing. And even if those who are mighty and powerful might ignore the court's decision. Occasionally, those who have been mighty and powerful are the ones who have run to seek the protections of the court when the circumstances have changed. The courts must continue to give justice to all and sundry, irrespective of their status or former status. What orders should we make in the motion before? So then, my Lord, I make 3 points with regard to what is public interest, as understood by the Court of Appeal. Number 1 is that public interest means enforcement of the constitutions of Kenya. Secondly, my Lord, to make the point from what we have cited, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my Lord, it will be the submission that this reinforces the huge burden that this court must undertake. And my Lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare ourselves with a dictatorship, that as a constitutional democracy, we can live with the decision. As my learned colleague Mr. Ngoya was saying, we cannot possibly live with a decision in which we would be seeing the Chief Justice, if that were to be the case, you would be seeing the Chief Justice swearing on Kindiki while we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my Lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties. So that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a whole of victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the Constitution is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the Constitution have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our Constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier, the desire of the makers of the Constitution was any person who will hold the office of Deputy President and therefore can potentially become President without an election ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political malice, is held by an appointed person. It is in public interest that an elected deputy president, except for the clearness of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. Now, the fifth issue is to do this, that this court protects the constitutions. I've already talked something about it, so I don't have to go much into it. My Lord, there are only two decisions before I sit down that I would like to point myself to. There is the issues of Gerongori versus Attorney General. It is one of the cases that are before you. The facts in Gerongori are notorious. And they are also notorious for the simple reason that that decision, those old advocates who are there, in a form which Dr. Gibson Kamakuria tells us, that it was largely, though it was a three-judge bench, it was written in the style of Chief Justice Madan. My Lord, that issue says something that is important to me, the young advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice in the simplest meaning, in plain English. You need to ensure everybody has a fair and square deal. This is to say that at the end of the day, everybody will leave the court and say, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written, and that is why it is celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason. Whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them, it is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my Lord, it is for good reason. All of us celebrate Justice Madan because he's trying to do justice. But my Lord, in the same case, the older lawyers also told us about Alan Hancock, about Dagdale, and even about Chunga. They tell us all these things. But my Lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock. So that, my Lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before him, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite before I hand over to Melanie colleagues, Professor Ogata, has it gone? Oh, I thought whether you have disappeared. But before I hand over to Melanie's colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how you are going to...
Yes, sir. Yes, my Lord, we are budgeting. Yes.
No more than 30 minutes.
Yes, but my Lord, my understanding... Yes, we will try to do our best.
No more than 30 minutes.
Thank you. We will do our best. My Lord, for purposes of this case, it is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that will be read by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarized themselves, as Macharia tried to do, with what other courts internationally have said. There is just like a small issue that I want to address myself to. My Lord, in 1928, in the case of Olmsted versus United States, one of the most celebrated justices of the U.S. Supreme Court, Justice Brandeis, said as follows, and this is important: our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. End of quote. I quote the words of Justice Brandeis in order to make the point that in the matters, the proceedings before this court, we have been treated to a scenario under which an impeachment process that, if you read the constitutions clearly, is a process that ought to be a legislative one, a process conducted by the legislative organs of the Kenyan state has been converted into an all organs of government project. With the result, my lord, that if the petitioners turns out to be right, you then find ourselves in a situation whereby, like in BBI, this process of impeachment of the deputy president may may end up being indicted as being a process that ended up being a government project, contrary to what was clearly spelled out by our laws. And my lord, if it turns out that all laws were broken, and virtually out of the constitutions, I was counting them yesterday, it looks that 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken. Then we have a situations that Justice Sundays had in mind when he talked about the government, which should be the lead in upholding the law, ends up being the principal breaker of the law, the principal violator of the Constitution. It is within your hands, your lordship, and your lordship, to ensure that does not become our scenario. My lord, Marshall, my colleague, emphasized something, but I want to finish by adding something. My lord, in June 1982, when Kenya was legislated into saying that Kenya is a single-party state and KANU is the only legitimate organ, this was through a long process. Honorable Rengo, Honorable Wite, Gibson Kanamkuya have told me the intricacies of the day, what actually happened. My lord, the month of October 2024, we have experienced events that the senior citizens of Kenya likened to the events of June 1982, when everything in Kenya suddenly changed. Kenya ended up to being it was a restricted democracy, but all the guardrails were removed after June 1982. Your lordships, I urge you that if these petitions, if these proceedings end up in a manner that does not uphold our constitutions, then this constitution may face the same plight that the former constitution faced after the events of June 1982. We must hold and ensure the events of October 2024 remains regrettable and an aberration on Kenya's constitutional order, not the norm. My lord, I am thankful for the time. My learned committee is out. Thank you.